Hey, here we are again. Last time we talked about the Fifth Amendment. We started talking about due process, fair trial rights. We started talking about things like self-incrimination and double jeopardy and your grand jury protections. Today we're going to move forward, talk about due process in general, give a couple examples. Hopefully we'll get into talking about eminent domain, and maybe, as promised, eventually we will have to deal with abortion. So let's remind ourselves what the Fifth Amendment says, and here it is again. Grand jury protections, double jeopardy protection, self-incrimination protection, and today we're going to talk about this phrase right here where it says you shall not be deprived of life, that would be like execution, liberty, that would be your freedoms, or property, that could be in the form of fines or other kinds of just legitimately property, without due process of law, which is loosely interpreted as your day in court, but we're going to talk more about what that means in a second. And finally, we're talking about this: private property be taken for public use without just compensation, nor shall. The idea there being that we'll talk about eminent domain. So let's talk about due process in general real quickly. So it's this section here that cannot be deprived of life, liberty, or property without due process of law. And like I said, generally that's been interpreted to mean that you have your protections in court to say that, hey, if something is going to be taken from me, whether that's life or my freedom or my property, that I have protections in court to be able to prove otherwise, that it should not be. I want you to remember that your due process and other protections have been incorporated into state laws, and having the states have to deal with them because of the 14th Amendment. So though due process, like every other right in the Bill of Rights, is basically only a limitation on the federal government, the 14th Amendment forces the states to obey it as well. There's two types of due process I want to talk about briefly: substantive and procedural. Basically, the difference between these two terms, vocab terms probably need to be known for a quiz, is that substantive means that the law itself is violating your due process rights. Essentially, something like maybe forcing you to, the law saying that it's okay to torture you in order to get a confession. That would be a substantive violation of your Fifth Amendment due process rights against self-incrimination. Procedural just simply means that, like, hey, the law is not bad, but the way the law was executed violated your due process rights. Say in the case that, like, maybe your Fourth Amendment privacy rights were violated, not because the state of Montana says that the police can do something that was a violation of the Constitution, but more because the police did something that wasn't in the law, and so therefore the procedures they followed violated your due process rights. So that leads us to talk about eminent domain, which is actually a topic that we've talked about before, and therefore I'm going to try to go fairly quickly through. But essentially a kind of due process where without, we're talking about your day in court and your protections from the government doing things to you, in this case taking your private property without, just compensation, without reason, so your due process rights. Eminent domain comes from the Latin phrase essentially meaning superior ownership, and it basically operates on the idea that, the United States and Missoula County, Montana, they all own the land at a larger level than you personally do. They have superior ownership. You have ownership, but they have superior ownership, so eminent domain. But the idea is that because the land is, as the cartoon says here, the United States or Montana's, that if necessary, they can take it for public use, but they must, one, go through due process. You have the cannot have your property taken from you without due process, and two, it must be for public use, and three, you must be justly compensated for it. You guys are probably familiar with eminent domain from the movie Emperor's New Groove. Here, the emperor wants to take the house of the main character in order to put his castle on it, or his summer home, is then essentially taking private property for government use. So this concept of eminent domain is used by the United States and by other countries and by cities and counties. Most often, it actually happens at the local level, but for a variety of purposes, we need to build a highway, and that highway's got to go somewhere, and a lot of times it's going to go through somebody's property, and we would like them to sell us that property so we can build the highway out there behind me. But maybe they won't, and so therefore, what are we going to do? Just not build a highway? No, it's good for the entire nation, public use, and therefore we need to be able to have some kind of way to say, look, you're not going to let your one house, your one ranch, stop us from building something like the interstate highway system, which has been one of the best things America's ever done for itself. So eminent domain is used in this way. National parks, maybe building Air Force bases or airports or schools, public use items. Those are reasonably uncontroversial. I mean, they're controversial because we get into questions about should they or do they need to be done, but they're not controversial areas which eminent domain is frequently invoked. But we'll get into some controversial ones just in a second. So we now know what eminent domain is. It's the taking of private property for public use, coming from the concept of superior ownership. It's considered an inherent power of the government because of that line in the Constitution that says that here's your protection. Your protection is you have due process and you have the promise of just compensation. Well, the founders wouldn't have promised those things if those things weren't sometimes going to be needed. And so therefore, the founders, the evidence suggests, must have believed that this is something that governments just have to do, that the government has the power to do this occasionally, and our proof for that statement is that they gave us the protections that citizens have when it needs to be, when it's going to happen to them. So it is considered an inherent power of the federal government. And those protections, I keep saying it, you have the due process, you have just compensation, and it must be proven in due process that it is for public use. We do see a couple examples of this that, just kind of high profile examples. Cities do this all the time when they need to reorganize their city as they grow. What used to be residential is now next to a waste plant, and that's just not good. A school is next to a chemical factory. Those things need to be readjusted. And so we see this kind of thing, especially in fast-growing cities, where they frequently need to rearrange the way the city's organized. Cowboy Stadium was built in Arlington, Texas. Arlington, Texas basically has, two huge industries, the Cowboys and the Texas Rangers baseball team. And when the Cowboys said, look, we can't make money with the old stadium, we need a new stadium, the city of Arlington's like, well, where are you going to put it? And it's like, I don't know, but if it's going to stay here in Arlington and you can still have that business, it's going to have to be somewhere. Well, the city of Arlington went looking for places, and they, basically bought up the houses that were in that area, and so they could build this stadium, which is so vital to the economy of Arlington. There were people who didn't want to sell, and those people were subjected to eminent domain. Kelo New London is the big court case that we've talked about in class before that is pointed to as like that really changed people's perceptions of eminent domain laws. So in Kelo, Suzette Kelo was, had her house threatened along with everybody in her neighborhood because the city of New London wanted to build this office park and all kinds of other businesses in order to increase the the profit, the health of the city. She fought it because essentially saying, look, my house should not be used so that other people can profit. Kind of a Jerry Jones thing here. Understand that eminent domain is used for things like schools and hospitals and Air Force bases and roads, but this is not that. This is, you want to take my house so that somebody else can have something, and why is their version of the American dream more important than my version of the American dream? So that winds up going to court. essentially in court, it was people were like, look, if we're just simply talking about what's good for the city and we're going to base that on, okay, where's the most employment and taxes coming from, well, then everybody's house would create more tax revenue with a Walmart. Everybody's house would be better for the health of the economy of the Missoula, for example, if you had a shopping mall on it. And if that's going to be how you determine what is going to be allowed under eminent domain laws, if that's going to be determined, if economic development is going to be the reason we're going to let government take private property, well, then everybody's house can be taken. On New London's side, they said, look, we're trying to make the city of New London a better place. And part of that means providing for jobs and employment and tax revenue and the things that cities and people that live in the city need. That can't just happen. You have to sometimes reorganize the city. We needed to say, look, that office park now is going to be an industry part, and that residential is now this. And so this is part of the city's job is making sure that the people of the city can earn a living, and that means attracting jobs. And you don't attract jobs just by saying, hey, bring jobs. You need to bring and build the kinds of places jobs want to come, and that's what we were trying to do here in New London. Eventually, New London wins that court case, but it does create a lot of concern because, hey, as we talked about in class, look, if all you got to do is show that, my house is worth more when there's a Walmart sitting on it, then that means everybody's houses can be taken. And Kelo New London, while it still stands as law, basically forced a lot of cities and states to re-examine their eminent domain laws, so that kind of thing can't happen. But here in Montana, we have a couple interesting, in Missoula specifically, we have a couple interesting cases. So a couple years ago, Missoula took over, you can see eminent domain, took over the water system. Missoula claimed that the water system was old and wasn't being taken care of and was being, essentially the private company, this Carlisle group, Mountain Water, that was, maintaining it, wasn't doing their job, and they finally got frustrated enough, they said, we're just going to take it. And number one, that was a court case. Can they or should they? Do they need to? And when that was determined, yes, then it became a just compensation issue. How much should they pay for it? Mountain Water claimed that it was, worth millions upon millions of dollars, and the city of Missoula said, no, it's worth a couple million maybe. And so, they fought over what's just compensation. The other concept of just compensation is actually down by the Walmart there at Mullen and Reserve. All those trees are an awesome idea. They're there to essentially be a waste wastewater treatment thing. The wastewater gets put on the ground and it percolates through the water, and the trees eat up the waste, and the water that comes out on the other side and goes into the river is cleaner than if it had been chemically treated in a facility. The problem is, for 6 months of the year, especially when it gets hot, it smells like sewage, and all those condos that live on the other side of the road, they smell like sewage. And if you bought one of those condos for $200,000, well, no one's going to buy them from you again for $200,000 because it smells like sewage for half the year. So you sell it for $150,000, and the argument can be made: did the city of Missoula take $50,000 worth of property from you, and do they need to compensate you under eminent domain laws? Generally, the Supreme Court says no, that's not. We're not going to get into those kinds of things, but there is an argument to be made, and occasionally such arguments do win. All right, that's number 2, due process and eminent domain. Next class period, next video, abortion.